Good morning, Ms. Ortiz.
I know.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be.
Today in Harris County, a driver is found passed out behind the wheel B, AC barely over the legal limit. But what the judge does next? Shocking. Then, another defendant faces bond revocation. A tearful grandmother pleads, and an assault case unravels with twists in a drive-through fight. Courtroom drama, legal bombshells you won't believe how it ends.
Ortiz.
Yes, Judge, I missed the last name on this defendant.
Ortiz. Yeah.
All right,
Today, in Harris County, a driver is found passed out behind the wheel BAC, barely over the legal limit. But what the judge does next? Shocking. Then, another defendant faces bond revocation. A tearful grandmother pleads, and an assault case unravels with twists in a drive-through fight. Courtroom drama, legal bombshells you won't believe how it ends.
vehicle with the engine on. The witness from Houston Fire Department stated that they put the vehicle in park and took the key.
The fact that firefighters, not police, took the keys out of the ignition tells us one thing: Ortiz wasn't just intoxicated, she was completely unresponsive. That gives serious weight to the state's argument that she posed an active threat. Remember, public safety always comes first in DWI cases. But the defense might push back on who officially observed what Tandy win.
In one-leg stand. The DIC was read and the defendant consented to a breath test. And
Here's where it gets interesting. Her back results are just barely above the legal limit of 0.08, literally by a hair. That gives the defense just enough room to argue margin of error, especially if protocol wasn't followed to the letter. In class call, DWI cases like this, technicalities can become turning points. Would you consider that enough to convict? Let us know in the comments.
Before they started doing all the tests. Right.
If I may.
Are you losing?
So, Your Honor, I am in the DIMS. It does not say. Yeah, I know. In the DIMS, it does not say I am checking the office report. I know. I know your feelings on that, Your Honor.
Mr. Ortiz, if you watch the news every single day, we have someone dying from a DWI in our county. It's not cool. If you want to go get lit, fantastic. Take a freaking Uber. $40. And one button on your phone. Anywhere you want to go, man. I'm going to find no probable cause in this case.
Wait, no probable cause. After field tests, breathalyzer, and a passed out driver. This is where judicial discretion flips the script. The judge doesn't just want numbers, he wants context. Were the officers thorough? Did they skip vital steps? The decision may shock you, but it shows how law isn't just black and white, it's all shades of gray.
And?
Was presumptive positive for THC.
And now, the courtroom turns its focus to a new defendant, same courtroom, different storm. THC, failed drug tests, and a history of non-compliance. The shift from alcohol to marijuana raises new legal questions. How long does THC stay in the system? What counts as new usage versus leftover traces? These are tricky waters, even for seasoned prosecutors.
I don't know. Off the top of my head.
Case has been open since December. We reinstated his bond in February.
Who ordered it in December?
We ordered you since December not to use, and you're still testing positive. It's unacceptable. I'm now revoking your bond.
This moment, right here, when the judge says, "I'm now revoking your bond," is where reality hits hard. This isn't just about Lutz, about trust. The court had already shown leniency once, but continuous positive tests, that's a clear violation. The bond revocation isn't just a punishment, it's a statement. We gave you a chance, and you blew it.
Use. And I told you over and over not to use, and I even reinstated your bond once, and you're still testing positive. No, because then,
Well, you're still at Morton Ranch.
am I supposed to feel bad because he's continuing to use? You know?
If it's going to go a certain route and possibly go away, I just ask.
As much as I love you, Greg, if I let him go now, then I'm telling him it's okay for you to do what you're doing. And it's not okay. I've warned you repeatedly not to, and you continue to test positive.
This is a powerful moment. The judge isn't just citing rules, she's pouring out frustration, practically pleading for accountability. Her words, "As much as I love you, Greg," Tell us this isn't personal anger, it's professional. Heartbreak, she's seen this cycle too many times. Rewatch this part. You'll feel the emotional weight behind every word.
It's to know that we mean business, that we're not here
Understand.
flapping our gums for nothing. Because, really, I've already reinstated the bond once, and he's still doing whatever he wants to do. It's unacceptable.
Okay.
So, I'm setting the bond at $5,001 today.
Did you catch that? A bond of $501, not $500? Why the extra dollar? Judges often do this to flag special circumstances, signaling that this case isn't routine. It's a subtle but clear reminder, you're not slipping through the cracks. This time, the court is watching, and next week could change everything.
I don't know, he's playing something responsible. So it's a part, like, things like, you know,
Greg, don't. You know what I mean?
I get it, Judge.
Okay.
I will talk to the state. I will talk to Mom.
Talk
I have
again
one
on-
other case I need to talk to you
We'll
about.
talk again on Monday.
Yeah, that's fine. I'm here every day.
All right.
So
Thank you so much for coming.
just give me a second. I'll talk to you.
Thank you so much for coming. I appreciate it.
This is heart-wrenching. The grandmother has raised him since infancy, now raising his daughter to her voice cracks, but she stands firm. This is a moment of pure human pain, where family meets failure and love battles consequence. These aren't just court cases, they're generational stories, full of hurt, hope, and hard choices.
I have another case, Takesha Chase. I was going to come to the court without an agreed recommendation to see if the court would consider a deferred adjudication. She has no Texas history. She does have some history out of state.
No, but are you opposed to it prior? And why?
So, Judge, I think we made an offer. We have planted that.
Now we shift into a new case, an alleged assault at a drive-thru. But it's the delayed police report that raises red flags. When the alleged victim doesn't report immediately and only calls the next day from a law office that introduces reasonable doubt. Was it retaliation, legal strategy, or legitimate trauma delayed by fear? You decide.
Called the cops the day after. It was they were in the drive-thru at Whataburger. Complaining witness hits the back of my client's car. Client's upset. Argument ensues. Opens the door. They throw some punches. Okay. Done. Complaining witness does not.
This is a turning point. The complaining witness is asking for maximum punishment, even though the physical injuries seem minor, a burst blood vessel, and some redness. This contrast between injury severity and desired punishment adds complexity. Is this emotional retaliation or a cry for justice? Let's hear your thoughts in the comments.
That is.
Is your complaining witness asking for max time or something?
She didn't ask me for max.
Right.
And she didn't discuss that.
How bad are the injuries?
So she said there was a blood vessel pop in her eye and redness on her face and eye.
Did she verify that?
So based on injury photos, we do have an injury photo.
She has no criminal history, right?
She has out of state, but nothing in Texas. I mean, body cam. I didn't see.
It's nothing violent.
I didn't see anything on body.
I'm
cam.
okay. I'm okay with it.
Okay.
Yeah, for sure.
All right. Do you want me to set it for a plea or do it now?
Well, it's 191 days. Is she here now?
She's here now.
Why doesn't we do it?
Okay, I'll do it right now.
9 days in jail, with 5 days already served on paper. This sounds like a slap on the wrist. But here's the kicker. This plea locks in a lifetime record of family violence. He may walk soon, but that label never leaves. If he so much as squeezes someone's arm again, it's a felony, forever. Think about that trade-off.
This is going to go on your record. It's going to be there for the rest of your life. It's even there after you die. This is important because there's an affirmative finding of family violence. What that means is that if you ever pick up another one of these cases, you will be looking at a third-degree felony. If you ever pick up a gun or ammunition, you could be looking at potential further charges as well. By doing this plea, you can never own a gun or ammunition or be in possession of such. You understand?
Sure.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, and correctly cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported excluded from the country, denied naturalization, give up the right to appeal. That's why I say, after today, you can never come back and try to change this because you just don't want it anymore. Do you understand, sir?
Yes, sir.
There's affirmative finding of family violence, which is why I was telling you, you pick up another one. You understand? And I'm telling you now, an assault is not like a drag down, beat down. You merely
This moment hits hard. A lot of people don't realize pleading guilty to family violence disqualifies you from owning firearms permanently, no matter the circumstances. This isn't just a warning, it's a life-altering legal line. For many, that alone makes a plea deal worth fighting against. What would you do in this situation?
You want me to take the residential restriction off?
Yes, Your Honor.
Do we know what the complaining witness wants?
Absolutely. The complaining witness not only wants it removed, but the complaining witness has contacted the district attorney's office between yesterday and today. I spoke with her yesterday. I also emailed the state.
Cole, you verified that?
It's a DVD issue, so
Okay, as long as they're okay with it, then I'm okay with it as well, and we can amend it.
okay.
I just want to make sure that they're on the same page, that they know about it, and they're okay with it, and then I'm okay with it too, Alan.
Yes, Your Honor.
Okay.
She's on standby, by the way, if you guys want to call her.
Okay, yeah, we'll give her a call.
Well, you don't have to call. It should be in the notes, hopefully.
Well, the note says that defense counsel says the complaining witness explained it was a big misunderstanding.
Okay, I don't know, maybe,
This morning's email, I don't know if you got it, but it also says she's waiting for you guys to call her. Her number is this, and she's called you. And I was on the phone when the number called you too.
Did you send me the?
Alan, you said she's outside?
No, she's on the phone. She's waiting for their call.
I'll have someone reach out here momentarily.
Thank you.
Okay, all right. Good luck to you, Mr. Birch.
From DWI dismissals to THC violations and emotional family pleas, today's courtroom gave us everything: law, heartbreak, tension, and raw human choices. We saw how judges balance compassion with consequence, how tiny mistakes spiral into big ones, and how even minor charges carry lifelong weight. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Justice isn't always clear, but we'll be here to break it down every step of the way.